The views, opinions, and recommendations discussed and expressed by the task force are not the views, opinions, or recommendations of the Division of Real Estate or the Department of Regulatory Agencies. And on that note, I will call roll. Jose Trujillo.
Here.
Nick Altman.
Here.
Joyce Akahenda. Peter Siegel.
Here.
I am here.
Jesse Loper is absent. Representative Riggs. Senator Fields. Lee Friedman, he's going to be possibly late.
Here.
And Lawless Jackson. So we have a quorum. To you.
Thank you, Marcia. And as I said a couple meetings ago before we had the public meeting, we're doing some good work. I just want to remind you all of some ground rules we'd all agreed to, that we would limit each speaker's time to 5 minutes. That will ensure everyone has an opportunity to share their thoughts and suggestions. Once a topic has been introduced, please allow all members to speak before speaking again with any new information that you would like to add. Any new topics that you might have that you would like to introduce to be put on the agenda for a future meeting, we'll do that at the end of the meeting. And of course, I will call on the speakers in the order that their raised hand populates the screen. And I look forward to having a great meeting today. The first item on the agenda is Kiowa, the Colorado Common Interest Ownership Act. And I will open the floor for discussion on that. Lawless, did you have your hand up? Your icon.
I apologize. No. Did it pop up?
Yeah, so I just wanted to make sure I don't miss anybody. Because I do that sometimes, don't I, Connie? I just want to make sure that everyone that wants to speak has that opportunity. Connie and then Peter.
So I have a question about how we're going to proceed with this. I have, for example, 15 recommendations for Kiowa. And Mickey, I understand that you'll stop me, at the 5-minute mark. But is the task here to get them all on the table and then decide which ones we're going to talk about? Or I guess what I'm really wondering about is our ultimate report. And what I'm hoping that we can do, maybe in the Kiowa discussion, is get to a place of common ground. So can you frame that for all of us?
I will actually defer that question to Director Waters.
So Connie, I definitely think you can bring up the different issues that you've identified with Kiowa, and we can have a discussion, and whatever the task force decides about those different points, then I think we can move forward with putting that in the report.
Does that mean we're working on consensus or voting or?
Well, I think consensus would be a good thing, although it's been there's been a lot of diverse opinions, I think, based on our prior sessions. So I think we just need to see kind of where the discussion goes. Consensus would be helpful, though.
Yeah. Okay.
And Connie, I have a question. Do you have 15 different suggestions to add or change or enhance Kiowa?
So the Kiowa being on the agenda, it's actually been on the meeting agenda 2 different meetings now, and it was just sort of a placeholder for the last one in case public testimony didn't fill up the time. So there was no definition then, there is none now. And so what I have are some enhancements to things that are in Kiowa and some recommendations for things that aren't in Kiowa. It's been mentioned that it's been our task force has been contentious at times, and I don't disagree with that. And I loved seeing on the agenda this time that we're going with, when we get to finding authority and practices, what's working well and what could be improved, because in my mind, that's a place that leads us to consensus. I'm really interested to hear, for example, what Peter told us several meetings ago that he has in mind for some changes to Kiowa that have to do with fining practices and maybe foreclosure. Peter, I didn't hear you say foreclosure or not, but certainly fining practices. That answer your question?
I'm not sure, and I have to ask Marcia for a point of order, please. And pardon my ignorance, but wouldn't any changes to Kiowa have to happen legislatively?
They would, and I think this discussion can take on the same nuance as the one about finding authority, about what is working and what has room for improvement.
Okay.
And if I could jump in there as well, Mickey, part of what getting to common ground, at least in my mind, is about is, is everything working just fine, or are there some things that need to be changed? And could this task force recommend some of those changes? My biggest fear with the task force is it really started with the first meeting and Senator Fields saying very clearly, in my constituency group, there's a lot of conversation always about HOAs and how they work, and she's right. And so far, what we've had is a lot of conversation, and I am super hopeful that we could coalesce around, well, with some things. We might have some disagreements, but here's the common ground. How can we protect this but not impede that? So, so that's my hope for us.
Okay, good. Connie, the only thing I would suggest is that you said you had 15 different suggestions for Kiowa. I would just ask, since we have different agenda items on different meetings, if you have some of those suggestions, can we limit it to the finding authority and practices conversation? Would that be okay? Are some of your suggestions, do they fall within that?
So I feel like you're changing the rules from what we had last time. I would offer instead, since Kiowa's been on the agenda for 2 meetings in a row without parameters for what's there, I would suggest that you let us bring
Okay,
whatever
no
Kiowa
problem.
recommendations are.
No
Thank you.
problem. No problem whatsoever. Do you want
And
to go ahead and start?
I'm happy to let Peter take the lead on this.
Okay, Peter?
Thank you, Connie. Very nice of you. I've got some easy ones, and I've got some ones that are um, probably have more controversy to it. But let me start with the easy ones. And I think Kiowa, and this is specifically Kiowa, and there's others that are 1137. And when you talk to people, some people say, well, 1137 is now Kiowa. So do we want to talk? And maybe we hold off 1137 to yet another meeting, because there's so much to do just with existing Kiowa as it is. But I think, and I mentioned this in the first meeting, but I think that Kiowa in a lot of ways is outdated. The world has moved forward, and I think it's time for us to move Kiowa forward with that. And I mentioned taking Kiowa green. And there's many things, and I would be happy to do more research, but here's an example. Many things in Kiowa that I feel are costing HOAs, and that's the HOA's budget, additional money, and therefore the homeowners, and I think without reason at this point. So one of the requirements is that in Kiowa is that notices for meetings be given snail mail, right? Just kind of a normal meeting. You got to send out the mail. Well, that's, as I mentioned, that is expensive. And when you talk about big cost and calling them out, people, or a lot of people these days, would rather just get an email. A lot of the time you send it out snail mail and it just gets thrown away. So as an example, take Kiowa, and you take a deep read through Kiowa, and you pull these things out that are really an easy change, and the focus of being, let's make it more efficient and let's reduce the cost of the HOAs. And therefore it's going to reduce the cost to all the individual homeowners. If instead of saying the default is snail mail, why don't we say that the new rule is it's up to the homeowner of how they want to be communicated? So the HOA board would talk to the homeowner and say, yeah, email me or text me or mail me how you want us to communicate with you, and leave it up to each individual owner to set what their standard is. I would bet that you would have about 80% of the HOA, the homeowners through the state, would say, you know what, I really don't get my mail. I don't need it anymore. And leaving about 20%. And I think I had mentioned before that 20% would be a savings statewide, right? Not per HOA, but statewide of $1.7 million in postage and mail, right? So that's to me, things like that. We could take deep dives and take the time and go through Kiowa and say, you know what, this really isn't necessary anymore, and it's costing more money than it should for the HOAs. The other two quick ones, and we've all talked about, is reserve study. I know that what didn't get passed, what was suggested through the legislature and to the governor, but that included funding for the reserve study at a minimum. It should be a requirement that an HOA has a reserve study. Now, whether they apply that to their budget and actually have funding, at least and have, so that everyone can see what that reserve study is, so that if you're buying a condo somewhere or buying a unit, you know what you're getting into. Well, again, whether it's funded or not. And then the other thing that I mentioned is that budgets, and Lois, you might have said this, I don't remember who said it, but I mean, this is an obvious, budgets should not contain fines and fees. People shouldn't be budgeting, saying, well, we're going to catch somebody doing something wrong, or we're going to be fining people. That just should not be happening. Budgets should be based on, as Kiowa dictates, is actual expenditures, what it's going to cost to run the HOA, and then divide that whatever the metric is, whether it's square foot, doors, everybody is different, but should not include the fine. So those are my three focuses on Kiowa. The 1137, as I said, probably another discussion and at least another 5 minutes.
Thank you. I think I speak for the group when I say we did want to hear the rest of your suggestions, Peter. So I see
Okay.
I see Connie and Lawless have their hand up. They might want to respond to what you said, and then you could obviously pick up with those other suggestions that you had. Connie?
Okay.
I don't disagree with anything Peter said. Good job, Peter.
Okay.
Thank you.
No, I said I thought you guys might agree. That's okay. Lawless?
Hi, thanks so much. Okay, now everyone has 5 minutes, right?
And then
5 minutes plus 5
recycle,
minutes
and it
plus
just,
5
yeah,
minutes.
we're just trying to give everybody an opportunity to speak.
Yeah. Okay, so the first item that you mentioned, many more than I'd like to say. Homeowners don't even have email, or don't have computers, or aren't on the grid, for example, or whatnot. So mail is still the standard default, and I think it should stay that way. Homeowners have the ability in their respective homeowner portals to select a different method of communication should they so decide and they don't want to get mail. That's completely fine. And so that works because obviously they have reached out to the HOA. The other thing is we have a considerable amount of population who does not want to hear from or communicate with the HOA. And so they don't provide contact information to the association. And so mail again is the default. And quite honestly, I think one of the attorneys spoke on this last time. It is the standard notice medium that we use, and just because we now have email doesn't make it any less a legal standard or a legal method of communicating with the homeowners. So I would not suggest that go away completely. I didn't recall that. I think I'm moving to your issue with fines and fees being part of the budget. I did not I do not know where exactly in Kiowa you read that fines and fees are to be in the budget.
Well,
I don't recall that being in the law, but surely I could be wrong. But that is not the practice or good practice of community management to include funds from a venue that you have no idea whether or not it's going to be received or not. That's just good management. No budget should have, well, we hope 50% of our homeowners have a fine, and so let's plan on our expenses, based on that. That's just management. And so I don't know where a Kiowa clarification needs to be made on that issue in Kiowa. And then I don't think I clearly heard the middle item that you might have mentioned, but that's all I had to comment on was those two things.
Thanks.
And fines and fees are not part of the budget, or not.
Thanks, Lawless.
Revenue in the budget.
And Connie, I see you have your hand up, but I do hear the miscommunication that happened, so I want to give Peter a second to address that. Thank you.
Okay, thanks. So Lois, the first thing that I said as far as communication and where it's required, sending it by mail, what I said was it should be up to the homeowner what the default is. That's my comment. I said that specifically, yes, lots of people don't have email. Great, so their default would be mail. There's lots of a whole nother segment. That's all I'm saying is let's give that choice to the homeowner. And I know that would save money for HOAs. The other thing is I didn't say that that anywhere in Kiowa it says you should include fines or fees. I have heard, that's all I have heard, that there are homeowners associations that do that. And I agree with you 100%. That's an awful practice. And that it just should somehow be mentioned that, hey, this is not a good practice. It's pretty basic. You don't do this, but in fact, some people do. So they should be called to the carpet on it, right? And then the last one was just that we're dancing around reserve studies and the importance of reserve study. So important. At least it should be included that every HOA should have a study. What they do with it is totally different. That's a whole different level, but let's not throw the baby out with the bathwater. In this case, it's a minimum standard that everybody should have a reserve study, and it should be made available to all homeowners and prospective homeowners.
Connie? Connie. You guys, the conversation, part of what we like to have happen is for the conversation to flow. So Connie, if you don't mind, Lawless, go ahead.
Go right ahead.
I was just talking back with Peter. I understand, Peter, and all I was saying, I think, is that everyone does have the ability to suggest or to, figure out their default, but the default legally for the association should be mail, is what I'm saying. And then if a homeowner goes in and says they want email, cool, we send them email. Also, the most recent HB 221137 does require mail for collections. And so obviously we would not, if you change Kiowa, you'd then have to change every, 1137 to match up with. You don't have to mail these legal notices to the homeowners. I just don't think that getting rid of mail is a good option, but I do think that homeowners should be able to opt in, and they can, as far as I know. And then reserve studies, I don't believe there's anything in Kiowa that requires the reserve study. There is legislation that is being proposed supposedly for requiring an actual reserve study to be done. The only thing that was required is that there be a policy and a reserve investment policy and a reserve study policy. So in Kiowa. So just two clarifications.
Thank you, Lawless. Connie, thank you so much for your patience. You are up.
No worries. I really thought this was a place for consensus. So I guess it is what it is, and that's okay. The default being mail, I respectfully disagree with Lawless, and I do agree with Peter that Kiowa could be changed and sort of bring it into modern day times. The frame of reference, Lawless, that I hear from you is that in the associations that your CAMs manage, there is that option. And I will tell you, that option doesn't exist everywhere. And so Kiowa is sort of the default place for here are the rules of the road, even though a homeowner's only recourse for enforcing that is in court. But I do think that we have to get with what's happening with our planet, and that it's absolutely time to take a look for that. And Wallace is correct that if you the literal language that's in Kiowa, you have to look all the way through it and say, well, if we say this, then how does it impact that? But conceptually, if this task force is going to come out with anything more than, well, they met for 8 times and they talked about a lot of stuff, this is one where I would say we need to move in the direction that Peter is talking about, and we need to recognize that every HOA and every management company doesn't operate according to a model standard today. So that was my add to that.
Thank you, Connie. And we are still having any discussions about Kiowa that anybody may want to interject. Connie, you had some more suggestions, you said.
I do. I have 15, so I'll read them, and you can stop me if you want to, but I so appreciate that when we have an agenda that it gives us time to prepare for it. And we had sort of one blip on the radar where there were 3 different agendas and it became very, very difficult to prepare for. So I loved this one, and I thank you for it, and I've prepared for it. And if there are rules or suggestions for how we need to prepare for it differently in the future, I'm all about abiding by the rules, but I took this agenda and I ran with it. So my recommendation 1 is, as a consumer protection, create truth and common interest community purchases language in Kiowa, requiring a 1-page home purchase disclosure, which there's an initial draft sitting in the shared drive, or any home purchase in a Colorado common interest community. The disclosure could be updated annually with any legislative changes, and along with consumer protection, create the requirement for any HOA foreclosures to protect a homeowner's equity. So some data that went behind this one. The Foundation for Community Association Research published in 2021, the Colorado Community Association's Facts and Figures Summary, so specific to Colorado, all except for one point that I'll share, which includes these data points. Okay, the first one we all know. Colorado has over 10,000 HOAs. The number of homes in those HOAs was estimated by FCAR to be 893,000. The value of homes in associations was estimated to be, this has so many zeros, I'm not sure I can read it right, but I think it's 503,450,000,000. That's just a lot of dollars. So I just did a simple math equation and divided that number by the number of homes to come up with an estimated value of 563,000 and some change per home. FCAR also said, and this was a national perhaps number, this was the one data point that I said it wasn't necessarily specific to Colorado, I couldn't tell. But the homeowner's equity is 69.2%. So residents are paying $4.3 billion to maintain their communities, costs that would otherwise fall to local government. And by 2040, the community association housing model is expected to become the most common form of housing. So we've talked a lot about foreclosures and protection. As a homeowner advocate, I've never said we ought to dump foreclosures. I get that sometimes they're necessary, and I think there's a protection that we can do in there. So media research points to at least 250 foreclosures using FCAR data for the value of homes. That's $140 million, 943,250. Jose told us about a government assistance plan that saved 158 homes from foreclosure. So if we were to look at what happened if they went to foreclosure, that would have been another 89 million and some change. Add those together, that's $230 million. So is that foreclosure? Is that the cost of doing business? Maybe it is, and I'm not saying that it isn't, but I would like to protect homeowners' equity, and of just the $250,000 or 250 foreclosures, sorry, looking at them having 69.2% equity, that's 97,300,000 or 532,000, sees a lot of math, $729 in Coloradans lost equity. So that's my recommendation 1 of 15. And I'm happy to go to number 2 if we don't want to talk about that.
I was going to ask, do any of the task force members have any discussion on that? Lawless, you have your hand up.
Yeah, what's the exact recommendation?
Protect homeowners' equity in the event of an HOA foreclosure. That's the recommendation. The second recommendation is.
Well, no, I don't want to jump to number 2.
No, that was number 2. The first one was the 1-page disclosure. Right now, the disclosure.
Oh, okay, then I have 2 comments.
Okay, go ahead.
The disclosure, I feel, should rightfully be with the Real Estate Commission, where they actually, the forms committee puts together forms that better the process of purchasing a home in an HOA or anywhere else in the state of Colorado. So I feel like that form, because I did look at it, would be better served in the real estate transaction before people buy in the HOA community. Folks who have already purchased in the HOA community, I'm sure you could potentially mail that out to them and have them fill it in. But even when I've sent out for proxies, I get about 20 back. So I'm not sure how to actually implement that form in current purchased properties in HOAs. But absolutely it could be added as a disclosure and I think it would be a benefit actually, as a disclosure in the real estate purchase transaction. With regard to the second item, I apologize, I didn't realize it was second to the first. I think that the onus to protect equity is on the homeowner to make sure that they are taking care of their property. I don't see how the state or the law can be put in a position to do that for every homeowner. We're talking about whether or not they are carrying out the responsible homeownership in their property. For most people, I would say 99% of people, equity is the reason they purchase. And equity is the reason that one of the major reasons that they take care of their properties. It is the largest purchase most people make. And they care about that. And that's why we've only had 250 or so foreclosures over a 5 to 6 year period, not 1 year, 5 to 6 years. And we have 2.4 million homeowners currently in the state of Colorado living in HOAs. And that's probably not even accurate. It's probably more than that. And we have 10,500 associations, not 10,000, but we have quite a few associations here. So when I say those numbers, they put things in perspective. And I think that's super important when we're talking about going forward with legislation. To legislate an entire state over items that very few of the state deal with is not really fair to those 99 homeowners who actually do follow the rules and do what they're supposed to take care of their properties. And so that's the reason I think the numbers matter, and perspective matters, and context matters. And so I don't think that the state can be put in a position to, or legislation can be put in place that requires the state to somehow protect the homeowner from themselves. That's all. Thank you.
Thank you, Lawless. Marcia, you had your hand up?
So Connie, I just had a question for you. One of the
Yeah.
things that has kind of come out of the discussions is that disclosure needs to happen before the contract to buy and sell is executed. And sometimes it also seems like not only do people not understand what buying into an HOA means, but some of them also don't do their due diligence. So along the lines of a disclosure, do you think that there's mandatory education that should happen before somebody buys into an HOA?
I think that's a lot to mandate. What I think we have now is a form in the closing process that literally, if I understand it right, requires the seller to have provided the buyer with what they need to know about getting into a common interest community. So that's what the paperwork says. But what the process ends up being is the homeowner usually doesn't know. And so they turn around to their HOA and say, hey, you need to provide these documents. What the property management companies very often do is turn around to a third party provider, document X, we'll call them. And document X has a master database because they have a lot of community associations that they serve. They pile them all in there, the documents. Then the documents come back out. There's zero accountability for that. So the document company isn't accountable. The property management company isn't accountable. The CAM isn't accountable. So it would be lovely if you could do a brain transplant into a homeowner so that they would understand, but I don't think that's possible. I do think that a one-page disclosure, and it's a conceptual disclosure. And Marcia, I appreciate that you brought folks in from your team that work on that. And I heard when that happened, a lot of reasons why, well, okay, send us a copy of what you'd like to see and we'll look at it. And what I'm concerned about is common interest communities have been institutionalized in Colorado with Kiowa since 1992. And there are zero avenues for recourse for a homeowner when something goes south other than court. And we know how expensive that is. So I'm looking for something simple that requires a document to be put in front of that home buyer that says none of this is regulated. You may or may not have read the rules. The rules could change, by the way, even if you did read them. And so it's a gamble. And I think that's okay. I mean, it's a little bit scary, but at least homeowners would actually know. Marcia, I feel like you've been put into sort of a terrible position because you're having to facilitate this. And it took me up until about the last meeting to finally understand what you were saying when you said, well, this isn't anything that gets discussed here, isn't the opinion of Dora. I can't tell you how much I value Nick Altman, David Donnelly, Eric Turner for what I know they do to sort of bridge the gap with education and help homeowners understand. But I know they're sitting on expertise and knowledge that I would give anything for them to be able to lay out on the table here. I was so confused when Brian Farley came in. Brian's great and understands reserves studies very well, but so does David and so do Nick. And they present education that doesn't have anything to do with a sales pitch. It's about understanding all the nuances. So for me, it's challenging to come and sit here and know that they've got the expertise, that there's some things that we can do that would be, I think, relatively small in legislation. But I feel like I'm the Dora representative and the champion. And so it's really been a struggle for me to try and contribute here because I know that and because I so want them to be able to contribute. And I think I got a little off track. Sorry.
Lawless and then Joyce.
Okay, just wanted to clear up some confusion about the third-party document providers. There is somebody responsible for the documents that are provided to the general public or homeowners in the association, and that's the board of directors. And the board of directors hires a manager who may employ a third-party provider. That third-party provider only provides what the management company provides them to give to their homeowners. Every association has its own separate contract or the contracts with the management company, and the third party only provides, they only facilitate what the management company is disclosing on behalf of the board of directors. It's not a random database of 100,000 associations and they just go out there and try to pull it per name or something like that. Actually, it's very time consuming for the managers because we actually get updates from the third party provider that tell us documents have expired. They tell us they're out of compliance with Kiowa, various requirements that are required, and we have to meet those deadlines on a regular basis. That we get those emails about expired documents, meaning an expired document would be last year's budget in 2024, just to give an example. Or if we didn't have HB 1137 policies updated, then we might get a notification that our documents are out of compliance. So I want to clarify that the third-party provider is working on behalf of the association per the management company. They're not working in addition to, like, we'll get the documents for you. No, they get the documents from the management company that is contracted for them to facilitate that piece of the escrow transaction. So I wanted to clear that up so it doesn't seem like, they're just coming from anywhere. So it is very methodical and for a reason. And why does a management company pay a third party to provide those documents? One, accountability to also make sure that the documents stay unexpired. They get these notifications when they are, things of that nature, but also to unify the project and make sure we're providing everything that the homeowners association is supposed to provide in the process of escrow, which is also refinance, purchase, sale, etc. So I just wanted to throw that out there as clarification on that process. It's not as random as it might seem.
Lawless, if every property management company operated like I know yours do, none of us would be sitting here today. And I know that you were in the meeting where I talked about this happened to me.
Yeah,
So
you've said that.
everything I got was from the leftover home sale that fell through, and it was wrong there. So everything changed. There was a lawsuit and the governing documents changed. I didn't get the right stuff. I interviewed people on both my boards. And so, and that's anecdotal. That's one situation. And I have talked to other community managers, property management folks that you and I both know. And they've said, oh yeah, it happens all the time. And I won't name them by name because I won't embarrass anyone. But when there is an industry that hasn't been, that at least at this moment, from 1992 to this moment, hasn't been regulated, there's some safety things that we need to put in place. And if we're hard pressed to get a single sheet of paper that tells the truth, so that the person selling and buying understands exactly what it is, then I don't know where else to take it but to Kiowa. So you may not vote for it. We may not have a unanimous position here, but it is my recommendation to change Kiowa. And Mickey, I don't know how you're going to write that into the report. I worry about it. I hope that if we don't have consensus on anything, that at least you will have the documentation that addresses it from both sides. Otherwise, all of us are wasting our time here.
Thank you, Connie. Joyce?
Thank you. So far, I like all of the ideas that have been presented thus far. I do think a one-page disclosure, both Peter's and Connie's ideas, and I'm supportive of the ones that have been presented thus far. I do like the idea of a one-page disclosure. I think that's something that is really important to have, and I think it should be a part of Kiowa. In regards to protecting equity, there are a lot of people who lost, I think, well, Connie did the numbers, who lost a lot of equity. And sometimes it was over the bad behavior of HOAs. I understand what you're saying, Lawless, but, states do legislate a lot of things that don't impact a lot of people. And frankly, so do HOAs. And, I don't like the idea of trivializing it to say it's just 250 foreclosures because out of X number of homes. And so it's not a problem, because I can tell you, when you face a foreclosure like I did after decades of putting money into your home and paying your mortgage and all of that, as you should, that's significant. And while it may not have affected 10,000 or millions of people, to the people who are impacted, it is important. And when we are facing a housing crisis like we are in Colorado, we should not be adding to the housing crisis problem in any way or shape or form. And so that is what I have to say in regards to those issues so far.
Thank you, Joyce. So we have two proposals, the one-page disclosure, the protecting homeowners' equity. Connie, Lawless, you have your hand up?
Yeah, I first want to say I am not in any way trying to trivialize the impact of a foreclosure. I completely understand the impact of a foreclosure, but I also recognize what causes the elements that precipitate, that predate the foreclosure. Okay, I know that there is a significant amount of time that goes prior to actually foreclosing on a home. So Joyce, if you think that I'm trivializing it, I'm not. I'm just trying to put this in very contextual terms. The impression is all HOAs are bad and they're out there foreclosing and they're taking your homes. And I've heard I've actually heard legislators say those very words to their constituents. And I am dumbfounded because I know that that's not the case. So I'm not trying to trivialize in any way the hardship of our community. I empathize with that hardship, and I want to find a way to help. And what I feel is helpful is alternative dispute resolution. I feel that we need an arm. We've said it since the beginning. We need Fedora to have teeth. We need Fedora to administer a alternative dispute resolution to help those people so that we don't have any. I would be happy to not have any. I'm just trying to put the information that's out here in context and clarify some of the misconceptions or misunderstandings I see or hear being said, just to give further clarity. The other thing is I did work for the two largest locally owned and operated HOA management companies. Unfortunately, they're not anymore, but they were the largest, the very largest. And these were those standard practices in those companies. And for me, that's the only context I have to work with. And I'm here to bring best practices and let you know that best practices really are being exercised and practiced out here in my industry. It is not, there is bad behavior. There's bad behavior in every industry. There are mistakes in every industry. I myself have also received incorrect documents for the association I manage, right? I got the master association documents and not the actual association documents. But whose responsibility is that? That's mine as the manager to look at the documents, make sure they're the correct documents, and then make sure that my third-party provider is provided with those documents, right? So I'm just taking responsibility for those things and clarifying responsibilities of those things for the third-party providers. And there may be some other third-party providers out there that of course there are, that I'm not aware of. And yes, those mistakes happen. And like I said, I've even experienced it. But I definitely don't want the impression that I'm trying to trivialize the problem of foreclosures in Colorado. I'm just trying to put it in context.
Okay, thanks, Lawless. Joyce and then Peter, reminding you, Connie's got 13 more on her list. So I do want to get back to the list, but Joyce and then Peter.
And I'm not going back. I forgot 2 points. One, Connie, I wanted to hear more about how you envisioned or what you thought in regards to what legislation could be done to protect equity. And 2, I actually, I do like Marsha's idea of education. I know it's hard, but when you're purchasing a home in the beginning and you're not familiar with HOAs and, an education course, I think is helpful, so that people have some type of knowledge when they're coming into these types of situations.
Thank you, Joyce. Peter and then Connie.
Yeah, I'm just going to piggyback a little bit on what Joyce just said, and that is the importance of education. And Connie and Lawless were talking about there's this whole segment of self-managed HOAs and giving out documents that are not current. They don't know what documents to give out half the time. So it's the buck stops here, and no matter if it's self-managed or the HOA hires a management company, the buck stops at the board. The boards need to know what they're doing. So education, at least if there were monthly bulletins sent out and the boards were really involved, at least they got that information. It was placed in front of them on a silver platter so they knew how to get it. That's part of the training for board members, whether it's absolutely required or not, at least it's there. And I know Dora has spent a lot of time doing that, but a lot of the self-managed really don't have a clue of what documents need to, 1137, we need to have update 3 of the 9 documents, right? So think that a lot can come out of education, and a lot of problems through education, communication will, at least, I'm not going to say resolve themselves, but certainly be at a lower level to where it's not quite as exaggerated as they can be now. Thank you.
Thanks, Peter. Connie?
I hope I can keep track of which piece I'm answering here. Joyce, would you mind repeating your questions again? Because that's what I was trying to get to.
I was wondering like what you envisioned or what you thought like the legislation to protect equity would look like.
So in 1137, what we did is have a line that said you can no longer close based on fines and fees alone. That's just like one line. So it's a line that you add to the legislation. That's all. And the education piece, in an ideal world, I agree with you. But folks, a lot of you are in the real estate industry, so please weigh in on this. I don't know how you do it before someone buys into an HOA. You know, do you give them Nick Altman's number? You know, there's so much. And so I like the idea of education. I love that there's an interest in doing it. But when you're looking for a home, how would that education piece work, Peter? How would you see it working, Joyce? Because I don't know.
Oh, well, I thought Joyce was going to answer the question, so go ahead. Connie asked you, so go ahead, Joyce, please.
I was raising my hand to answer the question. So I'm thinking of just like a short little like Zoom or webinar education course. They could have something that's recorded that people can watch and just get some basic information about HOAs and what you're getting into with an HOA.
Would you require it or would it be optional?
I think it actually should be required. I mean, I think there's so much that people don't know, and if it's optional, they probably, if you're busy, you're not going to do it. But I think like the ramifications are so much when you buy into an HOA. I think it should be mandatory. And it's not that hard with all of the different ways that we have right now of disseminating information. To me, it's not really that hard. It doesn't have to be, you know, if it can be recorded, whereas it's accessible for somebody to just watch a video or something.
Thanks, Joyce. Lawless?
Thank you. Well, as a real estate professional of 25 years, it is not difficult. And the one thing I want to say is all of that exists already, meaning training for HOA board members, training for homeowners, all of that still already exists. And so it wouldn't be difficult to implement a mandatory training course for those particular homeowners who are buying in HOAs. A good example is when you are purchasing, I mean, this is my realtor coming up, but when you're purchasing a CHFA home or the type of loan based on the type of loan you're purchasing with, CHFA is a home buyer's down payment assistance program. They require you to take a virtual course. They used to be in person, but virtual course in home ownership. So to do the same for HOAs would not be difficult. I don't think it would be difficult because the information is already there. I've mentioned previously also that we have Community Association Institute, which has been around for 50 years, providing just this type of education to homeowners, board members, board leaders, anybody who is willing to go to many of these webinars, webinar presentations. And so I don't think it would be difficult for it to be a requirement for HOAs. What I do feel is that it would be punitive, could be considered punitive for all of those hundreds of thousands of homeowners who live in HOAs and already or have lived in HOAs or know to live in HOAs. They may feel like it's a major inconvenience for me to have to sit down and look at an intro to HOA living. But I don't think it's difficult to implement. I think it's warranted, and it would certainly help on my end where the management comes in, that it would not be something that they had to read, but they actually had to attend and sign off on. So I'm all for education.
Thanks, Connie.
I just wanted to ask Peter to weigh in on that, particularly because you were talking about self-managed HOAs. So could the task force come up with a recommendation that said we need to develop a 5-minute or a 10-minute required video on common interest community living if you've never lived in one before? How does that strike you?
I think that'd be awesome. I think tools to give the board members, and board members change out all the time, right? I mean, I work with some boards where they're, and everybody does, where you've got new board members every year. So something that can be sent to them and they can take a look at it and give them all this great information. So at least they understand the many layers of responsibility. They don't have to learn everything, but at least they have to know it's there. And so that they can understand what they need to farm out and what they can do themselves, and they understand the responsibility. But Connie, I think it's a great idea.
Thanks, Peter.
I'm not opposed. So is this an area of agreement? I'm worried about it.
It sounds like it is. I think the three, I think we've had agreement on the one-page document for the disclosure for protecting the homeowner's equity and education for the homeowner. So Connie, what is your next suggestion?
Thank you.
Connie, before you go, I'm sorry, Lawless had her hand up and I was looking at my notes, so I didn't see it.
I just want to clarify, I'm not on the equity saving or protection thing, but I am on the disclosure, if properly implemented with DORA in the purchase process. And second, because that's where you make a disclosure after the fact is after the fact, but and then the training is also, I'm also for requiring a video far longer than 5 to 10 minutes. There's no way you could describe HOA living in 5 minutes, but a video, well, we already have those videos. Intro to HOA living, period. And then put, it could be 30 minutes, maybe an hour. Even though that's not long enough. But anyway, I'm for that. I just want to clarify what those consensus.
Well, then I was thinking when you said that we need to define, do we want consensus or do we want it to be unanimous?
Oh. Well, I don't think you're going to have unanimous because some people.
And that's right. And that's why I had thought it was conceptually you all had agreed to it in theory,
Okay.
and we had consensus.
Consensus. Okay. Sounds good.
Okay, Peter?
I think, and Connie's asked this a couple of times, I think all these ideas should go to the legislature, but I think some ideas get weighted higher if they have more consensus than others. I mean, I might have an idea that nobody else likes, everybody hates. I still would like it to move forward, but having an idea that said, you know what, everyone really loved this one, it's going to have more teeth. So I think it all should go, but weighted.
Agree 100% with that.
Jose, you have your hand up, sir.
Yeah, I just want to throw in, the kind of my support of, I think that homeowner equity kind of, I don't know what Connie was saying there is I'm sitting there thinking about like, how do we, when she first brought it up, I was like, how do we kind of present that? How do we do, how is there some sort of legislation? And I like the way she said that, it's that one simple line in 1137, kind of to help with that. And then Lawless, I really liked your opinion also, your thought of, make it part of the ADR if we do that dispute resolution piece, is that just trying to figure out how do we actually stop a foreclosure from happening, or how do we let homeowners know that a foreclosure means that they lose their equity? In our program, we see a lot of people that get to that last, we might see them come to our program when there's a week left before the house is actually foreclosed upon. We try to get them in front of a housing counselor so that they actually get that education, knowing that these are their options. You know, a lot of times we can get that foreclosure paused, and it gives them time to really understand that, you know, the only way to get their foreclosure or to get their equity is to actually sell their home. So I'm thinking that ADR might be just another way to give them time and the resources to get them that information, because they may not know that. They're in that position of, you know, what else can I do? What options do I have other than lose my house? But there are options. You know, it may not be the best option, but the option to keep their any kind of equity they have might be to sell, but they don't know that. So I'm in favor of some sort of measure to try to help save their equity. And I did like the Layla's request of going through that ADR process. Maybe that can be part of that as well.
Thanks, Jose. Lawless?
I wish one of the attorneys was on, because my understanding of the foreclosure process is that, or the end result of a foreclosure, is you may lose your home, but the equity of the home does in fact go to the homeowner. And so this whole thing about losing your equity is I don't feel like that's correct. But I'm not a lawyer, so I just want to make that clear. When you go through a foreclosure, the point is to collect what's delinquent. The homeowner actually because I've been a realtor, I've seen people in foreclosure, et cetera, et cetera. The homeowner actually gets the equity. They just don't get the house. Which, you know, yeah, anyway, but they do in fact get their equity if they have enough equity after the foreclosure is finalized. But I wish one of the lawyers was on here that could really speak to that. And it is a process to get to foreclosure. It doesn't happen in 60 days or anything of that nature, but the alternative dispute resolution would solve and curb a lot of that.
Thank you, Lawless. Connie?
I was just going to say that when a home is sold for a song, there is no equity that goes back to the homeowner. And so I get that there's a process, but if preserving homeowner equity were a part of Kiowa, then I don't think homes could be sold for a song. One of the 1137 protections was that those related to the industry or the board could no longer use insider information about a foreclosure coming up to profit from that. And there is an attorney who is recorded on a webinar that is sitting on the website that bemoans not being able to tell his relative, won't name which relative it is, but that they can no longer benefit from that. So that's what I'm trying to shut down is, hey, let's be as fair as we possibly can. And this group isn't going to, get to the language that shows up or that doesn't show up in a bill. But I hope that I'm going to continue to be positive and hope that we can agree conceptually on some things. And so I will continue to stand for preserving homeowner equity.
Great. And all right, we've had 3 issues on the table. What's your 4th one? What's your next one, Connie?
Well, I don't know if I'm down to number 4, but I have it listed as number 2 because the other ones were combined. So
Okay.
this is under 3833.3209.5. So by not later than January 1, 2025, add a 10th responsible governance policy that is an anti-harassment policy. And this was just sort of fun. I had ChatGPT put together a conceptual draft, so I know what can be done. Related to that, by not later than January 1, 2026, add an 11th responsible governance policy for elections, because that's just a huge issue. But I want to speak mostly, so I like the idea that someone said, Mickey, could you write all the recommendations down and make sure they get in the report, whether there's consensus or not, because I think that's valuable, especially because we're having a hard time reaching consensus. So here's the example that I wanted to talk with you about. My master association of over 6,000 homes is experiencing escalating incidents of violence, including chasing staff on covenant violation patrol with umbrellas. There is currently a security concern with staff in one of our buildings. And this problem isn't unique to Colorado, as there have been shootings and other threatening acts against property management personnel across the country. I've seen it also work the other way around in more than one association where credentialed CAMs have launched direct bully campaigns against homeowners. So what I'm asking for there is 2 additional responsible governance policies and one about anti-harassment. You know, when we had public testimony last time, the opening speaker talked about, came to the task force and said, hey, what do I do if I have somebody who is harassing the board constantly? Harassment is a real thing. And in our political climate in particular, things can escalate and get out of control very quickly. So I certainly have no intention of trying to put all the meat on the bones, but I think it's something that we need to address to protect not just homeowners, but to protect staff as well. My master association has 6,030 units. The CAM is an executive director and she works for the association. She doesn't work for a property management company. She has, Lawless, she has every credential you have, plus she has large scale management. You probably know who it is. I nominated her for, and she got CAM of the year, not this year, but last year. She's absolutely outstanding. If you could put how Lawless manages and how this CAM manages together, none of us would have to be here. But since we don't, we are here. And in even my HOA, the one that's wonderful, where we have this absolutely fantastic CAM, we have violence, threats against our covenant patrol people. And it got so extreme last year that the association, and when we say association now, we're talking about the homeowners, paid for a car to put them in so that they didn't have to walk. It's labeled all the way around it that they are from the HOA and they are on patrol. And there are security cameras all the way around that car. We have 2 buildings in this HOA, and in one of them, we have a severe security risk for CAMs who work for us, who have been threatened, and it's turned into a very serious issue about them leaving the building at night, not so much coming in, but leaving the building at night. And so 2 board meetings ago, we were talking about how many tens of thousands of dollars it was going to cost to put in an extra door to keep them safe. So harassment isn't about homeowners, or it isn't about the CAMs necessarily. It's a real thing. And if we have, right now, I think we have 9 responsible governance policies. Harassment is one that I think we need to get on the radar of legislators, which is why I'd like it in the report, because it works both ways.
Got it. Okay. Lawless.
I 100% agree that harassment is on the rise for managers, and you can imagine what the gamut of those are. But the problem with it being a governance policy is the governance policy only binds the homeowners per se. Per se. The governance policies are how the association board is going to implement the rules and regulations of the association. The board is not going to and should not be responsible for the safety of every homeowner. Now, there's associations that have that and take it on. But they have, whatever they have, like security forces and whatnot. But I don't know if the governance policies is where that goes. I agree that and now that we are, having to take our lives in our own hands and go post, a covenant violation, or 60-day late notices on people's doors, that just escalates the potential, risk and so forth. So I'm not sure if it's a governance policy, but I definitely think that it's two-way, because there are homeowners who are belligerent and all that bad stuff. Emailing the management company 10,000 times in a year. I mean, the stories are horrendous, but there should be something. I just don't know if the governance documents is sufficient to. The governance documents have to be something that the association can enforce, is what I'm trying to say. And so I don't know how the association is going to enforce its own homeowner from performing that, from harassing. But it is two-way. So I do agree with that. Something should be done, definitely.
Thank you, Lawless. Any other comments? All right, Connie, the floor is yours again.
Thank you. This is under owner education, which we've talked about a little bit. So this is under 33.3, 209.7. The association shall provide or cause to be provided education to owners at no cost on at least an annual basis as to the general operations of the association and the rights and responsibilities of owners, the association, and its executive board under Colorado law. The criteria for compliance with this section shall be determined by the executive board, notwithstanding section blah, blah, blah. This section shall not apply to an association that includes timeshare units as defined. So that's the language that's already there. What I would add to that is something that I've talked about earlier, and that is proof of that association training must accompany the annual HOA registration in order for the registration and related rights and privileges to be considered valid.
Any comments?
Come on, Lawless.
I was trying to get my hand up.
There you go.
And so how does providing a copy of the flyer that I went over with my board, or I'm sorry, at my annual meeting for my training topic that year, solidify that all of my homeowners received it? Like, what's the addition for? We already do that.
So the addition is when the registration shows up in DORA, whoever is responsible for submitting the registration has to say, yes, we did that.
Oh,
I have yet to be in an association where a homeowner has any idea that they're supposed to receive that annual education. Most boards, in my awareness, are really sort of afraid of having to put it out there. And so what adding it as a requirement to the registration does is puts a spotlight on the need for doing that. And if they don't do it, then at least I guess they could lie, and say, yeah, we did
yeah,
it.
they could.
But
that's why I'm asking, like, how does that solve the problem? Like, are you talking about another line on the registration thing that says we did homeowner education, click? Because it's already required by law.
On this date, it is, and I don't think most associations are doing it.
Okay. We
All right,
are, I mean, we are doing it. because it's
Right.
required by law. The problem is that homeowners don't necessarily come to the annual meetings. I manage an association, 1,632 homes. The biggest day I had in 7.5 years of managing that association had 17 homeowners. So the education is there. We have that in our agenda. We're going to go over education. We're going to talk about insurance today. That's what I did this last year. We're going to talk about whatever we're doing, right? But you know, the 10 or 15 people in the room got it, but the other, 50 did not.
I would like them to tell Dora when they've done it. That's all.
Yeah, I know, but my point is, like you've already said,
It will,
they're just going to check that box.
if it increases some, it's worth a line and a checkbox in my view.
Okay.
Joyce, and then Peter.
I think it's a good idea. If the people are already doing it, then it shouldn't be a hassle for them. And for those who are not, it'll be a reminder that they should be doing it. So I think it's a good idea.
Thank you, Joyce. Peter?
Yeah, I'm always for education. I think that should be happening. My question, Connie, is really, there's lots of requirements for HOAs and lots of requirements for boards. And how do you know which ones you want to put it? I get it. You want to bring attention to this particular one, right? But there's lots of others. And are you going to say, let's have a checkbox on these others as well? I don't think that's where you're going, but that would be the next obvious question, right? Is where do you stop?
I don't remember how many pages there are on Kiowa right now, but no, I don't have a checkbox for every page, but
There's a zillion, right?
creating the awareness, I'd like a checkbox there.
Right. Okay.
All right. Any other thoughts or comments? All right, great. Next issue, Connie. Oh, wait, I'm sorry. Lawless raised her hand.
Does that require legislation?
Any
It's-
changes you guys are going to make in Kiowa would require legislative changes.
Oh, in Kiowa, right? But that's Kiowa. But in the registration, is that something that can't just be done?
I see Marcia wants to speak on that.
Thank you.
It would require a law change for us to, because the question that we would have without the law changes, so what are we going to do if they don't attest to having done that? We can't stop their registration. So it would require a law change.
Okay. Connie, next issue, please.
Thank you. This is about executive board member education. And I could cite the number in the pages, but I'll just read it. So my recommendation is that within 12 months of being elected or appointed, HOA board members must attend HOA board leader education. Does that sound familiar, Lawless? Training addressing governing documents and roles and responsibilities, association communications, meetings and volunteerism, fundamentals of financial management, like collections, investments, reserve studies, professional advisors and service providers, HOA legal considerations, association rules and conflict resolution. Annually thereafter, board members must attend HOA board leader training on legislative changes impacting HOAs. Proof of training for each board leader must accompany annual HOA registration in order for the registration and related rights and privileges to be considered valid. So, Lawless, we both know that CAI offers that training and it is absolutely outstanding. And I would put in a plug for it, except for I don't remember the date. We're doing one in February. The HOA office, Nick Altman and David Donnelly do related training as well, and there's no charge for that training. So we have board members who just like, any garden variety homeowner want to serve their community and they jump on the board and they have no idea what they're getting into. And it creates issues because even people who mean well, and most people really mean well, they don't necessarily go in with an agenda, will get really dug in with doing it how they think it ought to be done, and they need to have a little bit of training. So I'm going to say in advance of someone else mentioning it, I know that there will be resistance. And the resistance that I always hear is, geez, these are just poor volunteers. You know, what do we expect them to do? And what I honestly believe is that we Colorado, we Kiowa expect way too much out of HOA volunteer board members. CAI has written an absolutely outstanding document. It's called the 2016, no, it was written in 2016, the 2020 Governance Panel Report. It was put together by people across CAI and included, I'll mispronounce his name here, Gary Kajewski. Marcia can probably clarify that. But an HOA officer was involved in writing that. It is sitting in our shared drive now. And it essentially says, guys, the world is changing and we need to change with it. And the governance model that we have today just may not work. So my greatest hope is that the things that are outlined in that report, that it would be wonderful if we could all look at that, but the right entities need to look at that, and we need to change the governance model of HOAs. And I have an alternate in mind. I won't recommend it here, but I have one in mind. And in the meantime, we have what we have, and we can't not have we have to have it, too many negatives there. We have to have board members who are educated. And so until we get to a higher level of governing common interest communities, we've got to have not only owner education, but executive board member education. And that's how I would propose to do it in the moment.
Connie, I don't know if you saw Marcia's question in the chat. Is it possible that you could give her a list of the proposal, the suggestions you have? And Marcia, I'm thinking you're going to upload it to the shared drive.
We can do that, but it's also going to come into play as we're drafting the report.
The report.
So what I'm reading from here, or are you talking about the CAI report, or both?
No, your list of suggestions, like the different things that you want the education to cover.
Yeah.
I can only write so fast. So
That's right.
Yep, happy to do that.
And I don't write as fast as she does, and I'm trying. All right, Lawless.
Hello. I can tell you right now, it's like pulling teeth to get board members, and there is no requirement for training. So if you mandate training, I'm not sure who the board is going to be. Because again, it is a volunteer position. They're not being paid. The idea is that they generally that they hire a management company or a manager. You don't have to hire a full-on company if you don't want, to facilitate the operations of a corporation, and to require a board member. I'm not opposed to education. Don't get me wrong. I am not. But what I am opposed to is barriers to entry and dissuasion and pretty much, total turnoff to what's already very difficult to keep board members in action. They turn over yearly. And so for board member who gets on this year to do a training and then have to do it next year and then the year after that and whatnot, some don't mind. I'm not saying that they do. Some don't mind, but a lot don't want to do all that. They don't even want the responsibility. And so they don't sign up for the board. They're like, well, as long as everything's going good, I'm good. And that's what you see a lot in Colorado, is that, as long as everything's going good, the grass is getting mowed, I'm good. Homeowners don't necessarily want the major responsibility of taking care of the corporation they've decided to move into. That's why we have management companies and managers. They take on that professional responsibility. And part of that professional responsibility, hopefully, is to help inform board members as they go and to help inform them, because it's a lot. It's not like I could download my head of experience to any board that I'm managing in an hour, right? They don't even want that responsibility. Listen, we just want to take care of our community. We want to enhance the values if we can. We want to make sure that the grass is watered, et cetera, et cetera. That's it. And so what we try to do as managers is facilitate that and make it as easy as possible so that the board members won't leave, so that they won't know this is way too much work. I got to go, because they're not being paid. This is a volunteer position. And to put all of these restrictions and added requirements, not restrictions, requirements on top of come and serve and sit in the meeting and listen to everything that's going on monthly, it's just going to be a barrier to entry and complete turn off to most folks who are inclined to serve on the board, not to mention the responsibility that goes along with it.
Thanks, Lawless. Peter?
Sorry, lost everyone for a moment. So this may have already been talked about, but especially against self-managed HOAs, I love the idea of education on the first one in line. And if it's offered and out there, we should encourage everyone to participate, but to mandate it, really feel we're going to lose self-managed HOAs. It's something that, again, the volunteer position, and I get it, right? The argument is, well, you know what, we need to improve our governance, and we do. But if we still embrace the governance policy of volunteer boards, we need to make it as interesting and exciting for those people to voluntarily opt into an education program. Thank you.
Thanks, Peter. Lawless?
One other thing that the industry is currently bracing for is the Corporate Transparency Act, which is effective, and we have to comply by January 1, 2025. We're going to lose a whole host of board members because they're not willing to put themselves on the line for the association. Now, that might sound dramatic, but what I mean is providing I'm responsible for this corporation in the state of Colorado. And that requires, social security number and driver's license and something else, whatever else is required. So of course, CAI is trying to lobby against that in preservation of volunteer board management of associations. But if it goes to corporate board managing associations, it's going to be more costly for sure. And it's not going to be the friendly experience that homeowners have right now. I know some don't think they have a friendly experience, but I'm telling you, dealing with a corporation with a corporate-led board is different than dealing with a corporation with a volunteer homeowner board. It's going to be very different, and it's going to cost the association quite a bit much more money to pay board members to do that work for the association. So I just want to mention the Corporate Transparency Act is already going to shave off a few board members who simply won't provide that information.
Thank you, Connie.
I was just going to add on to what Lawless said about the Corporate Transparency Act. Most HOA board members, I don't think, are aware of what that is. And there was initially the thought that boards would have to register by the end of last year and be on board by January 1st. And it turns out the interpretation was it happens in a year. And it is a big deal. I agree with you. And I don't remember the fines now. I think it's up to Lawless, you can correct me if I'm wrong, but I think it's a $10,000 fine. And or up to 2 years in jail. In jail, folks, for board members. So in my mind, it's just another signal that says the model that we have today, it doesn't work. And what we really need to do is look at that governance panel report. We need a different model. But until we do, I'm about protecting homeowners as well as the associations. And so I made that recommendation, understanding very well what the pushback would be. And if we had an alternative governance model, it wouldn't be my recommendation.
Thank you. Joyce?
Yeah, I agree. I wish there was an alternative, because as you stated and has been said before, this isn't working. I also am always in favor of education, and so I would like to see the education piece, but I'm also sympathetic to the idea that people are volunteers, and mandating another thing on top of everything everybody else has to do really cuts into the number of volunteers that you can get, the diversity of the people that you can get, and it's really a barrier to entry. And so I know, like, I don't know, but I think like people always work better with incentives. Like if they were to get like $50 each off of their HOA dues or something, that would help increase, but that's not something that we can mandate. So I'm torn on this one because I want the education, but at the same time, I don't want to discourage people from volunteering.
Thank you. Connie, were you going to say something?
Well, sort of. I don't have it framed in my head exactly right. I guess what I think a recommendation could be here is that going back to, I don't know, I think it was the very first meeting, Rep. Ricks talked about board manager licensing, which would be like the extreme, right? And so I tried to help back off of that a little bit and say, well, okay, board member certification. And this recommendation backs even more off. It doesn't put a label on it. It just says, after you've been in it for a year, you need to get some training. But if, as a group, we believe that that's not really a realistic recommendation, then the recommendation could be that we explore the alternate governance model. And it's not going to get done by March 1st or April 1st or whenever that is, but that could be a viable recommendation, I think. Lawless, how does that strike you?
I'm for education and encouraging education. I'm not for mandating it for board members who are volunteering to serve their community.
And the alternate recommendation, how does that hit you?
The alternate is, I wasn't clear on where, maybe you could repeat it in a more.
Okay, so sitting in the shared drive is the CAI report on the governance model.
I saw it.
That everybody has worked on and said something has to change. Work towards what that looks like could be a recommendation out of the task force. So, I've talked before about an interim committee. I don't need to put a label on it. I just hope that there's recognition that there is something really positive that we can do, but we don't have the time in the constraints that have been given us with this task force to actually explore it.
I don't think that that is a recommendation for this task force. I think changing the model takes a culture change, which, as you can see, is very, very difficult. And far greater than you anticipate. Just make a recommendation and put a law out there. I don't think that's a matter or appropriate here in this particular task force.
That's fair. Thanks.
All right, Joyce.
I was gonna say that I don't see why we couldn't recommend just exploring. We're not saying to mandate anything or to do anything. We're just saying, explore, look into the ideas of alternative, governance. It's not mandating that anything happen within a certain period of time or that anything is done within a certain period of time.
Okay. All right, next up, Connie.
CAM licensure shall be reinstated and incorporated into Kiowa. I think there's a bill out there now to do that.
Lawless.
There is a bill out there to bring back CAM licensure, so I'm not sure why I mean,
I prepared this before.
I caught it. I'm just saying, it is out
Yeah.
there. It's been introduced. I'd love to see it. If we could get a copy in the shared drive, I'd greatly appreciate it.
David, I see you nodding. If you don't have that, I can send it to you. You've got it. Okay, great.
All right,
Yes.
next up, Connie.
I'll add that to the shared drive for everyone to take a look at. It, take note though that it is pending, so it's subject to changes potentially, but absolutely. Thank you.
Thanks, David.
Next recommendation, property management company licensure shall be created, incorporated into Kiowa. I have seen the CAM licensure report, but I'm only partway through it, so it may or may not have an element of that in there, but if it doesn't have it in there, the property management companies should be licensed, in my view.
Generally, I mean, whoops, sorry.
No, Lawless, you guys, when the conversation's flowing, don't worry. Just
Oh,
this
okay.
is awesome. Conversation's flowing. This is great.
Generally, the licensure of a real estate broker carries the company, and then the agents are sub-agents of that, or I don't know what they call them now, but anyway. And so I would imagine that's how, I don't know for sure, but I was licensed before. So I'm not sure how, I'm pretty sure the company was like, there was a license on the it's not separate from CAM licensure. There's a designated licensed CAM for the company to be able to operate under. But Marcia, you could certainly speak to that better than me.
Well, and so vernacular kind of bleeds over into the real estate broker program when you say property management. So we have to distinguish what exactly are people doing? Because on the real estate broker side, property management means that you've got a real estate broker that's bringing landlord and tenant together and they're negotiating leases. That's property management in that world. Usually we hear that term referred to over in the HOA world, and that's kind of managing the common areas, arranging for maintenance, that sort of stuff. So the other thing I just wanted to flag for you guys, when you start talking about licensure of CAMs or CAM companies, the bill that has been presented or was presented last week is to regulate or license the companies themselves. When you start looking at doing actual individual licensures like the CAMs themselves, that's going to have to go through a sunrise application and review process. So it wouldn't be legislation straight out of the gate to license CAMs. You would have to go through the sunrise process.
Thank you. Lawless?
Which is what? I mean, I'm not wholly familiar with the sunrise process, but I haven't seen the legislation that was issued last week. So again, I'm at a loss, but it's to license the way it's coming out from some of the attorneys. that are sending out blogs or whatever is that it's the CAMs, but you're saying in fact it's the companies.
It's kind of blurring some lines. It's setting the licensure at the company level, but then there's fingerprinting and education requirements for the individuals that would be performing the management duties under the company, which
Right,
is
the
a
CAMs.
little, well, so it's like setting up a licensure program for the individual CAMs without them actually having to have a license. It would be a company license. So that's not a model that we have seen in Division of Real Estate. So I think that's kind of one of the things that they may need to work out as the legislation moves through. But when you look at doing the individual CAMs, a Sunrise application will look at like what's the prevalence, what's the need for it, and if there's a need for licensure, like what's the lowest threshold, because Colorado is a regulation light state. So they want to regulate people at the lowest threshold necessary to protect consumers, but also not create a barrier to entry.
Right.
So they look at, are there insurance requirements? Are there education requirements? Is fingerprinting necessary? Like, what does the actual program need to look like? That's what the Sunrise application process kind of considers.
Okay, I think what I was asking was we had licensure like within the last 10 years. We had licensure, I don't remember the years, but it was like 2 years worth of licensure that we had. And we went through the song and dance, jumped through the hoops and all that, and got licensed. But at that time, my question is, how was the company licensed versus the CAM license? When I'm speaking broker, real estate brokers over here, not property. I mean, it doesn't matter if it's property management or selling real estate. The broker carries a license for the company, and then all those licenses are underneath that broker. I'm asking, in our previous licensure in the state of Colorado, what did that construct look like for the company versus we know the CAMs were licensed, but
we were still licensing CAMs that were kind of responsible for the CAM companies, but the CAM companies themselves weren't licensed.
Got it. Thank you.
So if the company was doing something that was in violation of the license law, the responsible CAM was the one that was getting disciplined for that.
Okay.
Whereas in the real estate broker side, we can take action against the company as well.
Got it. Okay.
Great. All right. Any more discussion? If not, Connie, what is up next?
Require any lenders that escrow taxes or insurance by no later than the year to be determined to offer an option to escrow HOA fees, whether or not lenders offer the escrow option in the event of any eventual HOA foreclosure. I stuck this in there again. The homeowner's equity must be protected. So Kiowa, we started to have this discussion and Dick asked me, he said, well, can you talk about what you mean by that? And the discussion got carried away and I never got to talk about it. So I'm bringing it back here. Here's what Kiowa says today. Unless otherwise specifically provided in the declaration or bylaws, the association may enter into an escrow agreement with the holder of a unit owner's mortgage so that assessments may be combined with the unit owner's mortgage payments and paid at the same time and in the same manner, except that any such escrow agreement shall comply with any applicable rules of the Federal Housing Administration, Department of Housing and Urban Development, Veterans Administration, or government agency. So in that 2016 panel report that I referred to earlier, it's called Community Next 2020 and Beyond, the Association Governance Model Panel Report. Here's what it says about escrow. One logical approach would be for mortgage lenders to escrow and pay assessments similar to the way taxes and insurances are currently handled. This also has the advantage of eliminating property lien questions. Unfortunately, this is the key part, guys. Unfortunately, while this was a common practice in the 1980s, many lenders eventually eliminated the option because it meant more work on their part. I didn't make it up. That's a quote out of that report. The report goes on to say that the real obstacle has been that the banking lobby is larger, stronger, and more influential than CAI's lobby. So in my view, as long as there are common interest community deed restrictions that require mandatory HOA membership, we need common interest community organizations, industry professionals, and advocacy groups to work together to ensure legislators provide this consumer protection for homeowners. Peter's question was, when it was talked about however many meetings ago, well, what about homeowners whose homes are paid for? Don't we want a consistent process to collect everyone's dues? We've said here before that one size doesn't fit all. So today, in one of my HOAs, here are all the options I have to pay my HOA fees. I can write a check, attach it to a coupon, mail it in. That's one. Two is I can go online to the HOA website and pay it monthly, quarterly, or prepay the whole thing for a year. 3, I can have the HOA automatically deduct my payment from my bank account. 4, I can walk in the HOA office, make a payment in person during regular working hours. 5, my HOA has a payment box outside its office to accommodate after-hours payments. And 6, I can set up automatic bill pay from my bank and direct payments to my HOA. So lots of different options. One size doesn't fit all. There's not just one way to get it paid. None of these options offer the protection that escrow does. So if you asked any of the homeowners featured in and we're all aware of this report, the Colorado Sun's August 14th article, who actually lost their homes to foreclosure, including some with similar experiences, they would say, yes, we need to include that recommendation in our report. So strengthening Kiowa's language about escrowing HOA fees isn't about the status quo. We don't need experts to tell us what we can't do today. We get it. We can't do it today. I'm making the recommendation for future change because I think this is one that can better protect consumer homeowners.
Discussion? Jose, and then Lawless, and then Joyce.
Yeah, actually, thanks, Connie. When you brought that up, one of our first meetings, it actually intrigued me. It was definitely a nice thought. And so I did a little digging myself just to kind of see what kind of the history was and so forth. I've been in the mortgage industry for a long time, and for as long as I've been in it, we've never escrowed for HOAs, but I was trying to figure out why. I did find out that FHA HUD actually did a mortgagee letter within the last 10 years. It might have been 6, 7, 8 years ago, where they actually presented that option of actually starting to escrow for HOAs, but it was kind of shut down. And it probably, you're right, it's probably what's the banking industry and so forth. I did talk to, I meet with Chaff on our program for other things, but I did kind of talk to them a little bit. They do a lot of servicing here in the state of Colorado. And they basically said that they would do it, but they would only do escrowing for HOAs if it was kind of mandated by the big three, the FHA, HUD, VA, Fannie Mae, Freddie. So if we were to push something like that, like you said, it would probably just be a recommendation to maybe, put pressure on HUD and so forth to see if they can actually bring that back up again. But it's not something that individual lenders, because it would have to be a mandate kind of nationwide.
Thanks, Jose. Lawless?
Yeah, and I mentioned that, we did talk about this already in the first meeting or the second meeting. And the issue that I have with it is purely maybe it's personal, but talk about barrier to entry. Barrier, there is a sect of people who would be adversely impacted by the requirement to escrow HOA fees. Currently, a homeowner has to qualify for their mortgage payment. And that means they have to be able to pay not only the mortgage principal and interest, the taxes, and the insurance. And that number is difficult for the majority of people out there trying to buy houses. So to tack on an additional $250 would reduce the amount of money they could potentially purchase by at least $100,000, if not more. And make them unable to afford to purchase a home. And I am against that. So I'm for escrowing the assessments because, hey, the associations would get their money and it would be automatic, et cetera, et cetera. But a third of the home buying population would be wiped out. The potential home buyer population would be wiped out based on qualification alone. And we already have issues with that. We already have issues with less resourced, less advantaged folks being able to purchase a home in the state of Colorado. So I'm adverse to that based on the barrier of entry it would create.
Okay, Joyce? Joyce?
Thanks. So my understanding, Connie, of what you were saying is that this would be another option, not something that is mandated. So if somebody did not want to pursue that option of having it escrowed, then they wouldn't have to. If that's the case, then I am in favor of that. I think, especially during COVID, there were people who had issues because they were not living at home and they didn't get notifications in regards to a payment that didn't go through, and then it just kind of accumulated and snowballed from there. And I remember talking to one homeowner who said, like, she tried to see if it could come out of her, be part of her escrow. And she was not, her mortgage company would not agree to that or would not allow for that to happen. So I think having it as another option is good. Mine is escrowed. And so I can tell you it's a lot easier to not have to think about it and only have to think about paying my mortgage. So if that's the case, then I would support.
Thanks, Lawless.
I believe what Jose was saying is that it's an industry. The industry would have to buy in, but everyone else would have to buy into escrowing the association assessments. And I also believe, if I'm not mistaken, previously, Joyce, that you live in a special district. And that's why your HOA assessments are escrowed. They're not really escrowed. It's a different setup altogether from regular HOAs out here. So it is a different circumstance.
All right, thanks, Jose.
Yeah, you are correct, Lawless. It is an industry thing. Like, individual lenders could not decide that, they're going to escrow for HOAs and stuff like that. It would have to be an industry-wide situation. But one thing, just Lawless as well, I actually underwrote for a long time as well. And we actually took into account any HOA fees. They weren't necessarily on the front end ratios, but all the back end ratios included HOA fees. So that was something we did. So it wouldn't be another burden on top of it because it's already being included when cases are being underwritten.
Thanks, Jose. All right, anyone else? All right, Connie, what is next?
Enhance Kiowa to include the requirement that a majority of the membership must vote to approve any new common elements like recreational facilities and the like. There is a reference in Kiowa Today, 3833.3205, that talks about it, but it is not clear whether it's just the declarant for which that is required, or if it's after the declarant turns over control. So currently, the language seems to require that vote only for declarants. So after it gets turned over, frequently board members with pet projects, and this is true for several homeowners for whom I've advocated, they vote to approve additions to common elements that impose assessments and reserve expenses onto the membership. So it's I think this is a pretty simple one. Just clarify the language so that it is true for the association after the declarant has turned over control. And I talked to a couple of different attorneys and they read this different ways. One said, well, Jesus already in there. And the other one said, no, that's only true for the declarant.
Okay. Peter,
Kind of really interesting. So are you proposing a 2/3, like anytime you need to change a covenant, it's 2/3? Would it be along that that threshold?
I don't know what the vote would have to be. I just know right now it happens and homeowners don't get to vote. So I don't know, what should it be? Half, 2/3? I don't know what the vote should be, but right now there isn't in a general sense a vote every time that happens. What's your thought about it, Peter? What should it be?
Yeah, I think it would be a change of covenant and to include a common element that's not included that burdens the homeowners with something, some liability. Yeah, I think it would be a 2/3. Just, it doesn't make sense to come up with yet another threshold, right? Let's try to stick with the thresholds that are there. And as I said, just glue it to a covenant change.
all right. Lawless.
Okay, for clarification, I think, Peter, you're saying a covenant change and Connie's saying a Kiowa change. So what, I think, and as you've already, demonstrated, it's subject to interpretation, whether or not it applies to the declarant or the association. And the only thing I would caution against is when an association wants to, I would caution against making such a threshold so high that the association can never improve itself. So, there are improvements. Most improvements are within the scope of the current framework of the association. So for instance, they will replace their fence and they might have to do a special assessment to do part of that or whatever. And so they can already go and get funding from the homeowners per their approval through the special assessment process. But if the association wants to add a swimming pool, they don't have a swimming pool. What you're suggesting is that 50% of the association's homeowners should be able to vote on whether or not to add a swimming pool. But if you're talking about something that's already in the framework of the association, meaning they already have a fence, they need to replace it, or they want to upgrade it to a walk wall instead of, a fence because it's been blown down a million times. You want to be careful about the thresholds that you put on things like that, because then you limit the ability of the association to actually improve the association itself. That's all.
Connie, go ahead, please.
I was going to say I should have, pardon me, read the language and maybe that would sort of answer this. Under 3833.3205, contents of declaration, the declaration must contain a general description of the type of any common element that the declarant anticipates may be constructed by, maintained by, or operated by the association. The association shall not assess members for the construction, maintenance, or operation of any common element that is not described pursuant to this subparagraph, unless such assessment is approved by the vote of a majority of the votes entitled to be cast in person or by proxy other than the declarant at a meeting duly convened as required by law. And so I think that's saying majority. I'm just trying to make it the same after the declarant goes away.
Yeah, I think Lois, you made some great points, and Connie, yeah, I think it's already in there as 50.1%. Yeah. But is that, and again, for clarity, and this is something we all deal with when we're looking at specific documents, is that 50% of the people at any meeting, or is 50% of the people eligible to vote?
By the vote of the majority of the votes entitled to be cast in
Okay,
person or by proxy.
okay,
So-
so 50% of 50% plus of the
One.
entire HOA.
Yeah.
Okay.
Pretty clear.
All right. Anyone else? All right, Connie, what is next?
I have mixed emotions about it, but I'm going to bring it. Update Kiowa to focus use of proxies with the following language. Proxies may only be used to establish quorum or as directed proxies to cast votes on issues specifically outlined on an association meeting agenda that has been duly noticed to the members. Proxies shall not be used to elect board members. Only ballots, including secure electronic ballots, shall be used in board member and delegate elections, and those ballots shall be counted in front of the membership when possible. Directed ballots, whether electronic or paper, for other agenda items must be counted again in front of the membership or available for inspection immediately following the count. So if you were going to vote in the November election for a president, you're not going to cast your vote by using a proxy, right? You're going to vote for the person, X, Y, or Z, whoever happens to be on that ballot. So ballot or proxy harvesting will allow for someone else to cast your vote. So if it's on an issue, one of the folks who testified in public testimony towards the end of our last session talked about a lawsuit having to do with elections. And we know, any of us who've been around HOAs for a while know that elections can be very contentious and there are issues. So in my mind, this is one way to clean it up and simplify it. If there's something that needs to be voted on, that's an issue, it ought to be on the agenda. And then you can either show up and vote for it, or you can give your proxy to someone. And if you're voting for a delegate or you're voting for a board member, then a ballot should be used. That's what that says.
Lawless?
I'm not for any differentiation in a person's proxy.
Okay. Anyone else? Joyce?
So my question, Connie, is because I don't like the idea of proxy harvesting, and I do like the idea that proxies shouldn't be used for elections, but I'm also concerned about participation and people who, let's say, may not be able to like make the meeting or something like that. So what is the accommodation around that?
So proxies can still be used for issues, but a ballot should be provided to every homeowner to vote for whomever they're going to vote for. And a related issue that I don't know how to unbundle here is that there is context around any kind of HOA elections that typically, because of how the declarants write up the common interest community when they develop it, that preclude electronic voting. So in my master association, where we have 6,030 units, it's useful to have electronic voting. We have electronic voting, but then we double the process to comply with the paper ballots and the proxies that the declarant set up to begin with. So this is just a streamlining recommendation. I don't know how to fix the secure electronic voting issue, but this simplifies voting for the person, whether it's, the delegate or the board member. That takes a ballot. Anything else takes, you can vote on in person or however the meeting gets put together. And if you're not going to be there, you can do it by proxy.
Okay, Lawless and then Richard.
Currently, that actually is already the case. You can't, when you have your annual meeting, you can't vote on anything that isn't on the agenda. So that already exists. The second part of it, or the more important part of it, is my proxy is my proxy. And if I want to give it to my neighbor to vote for my board member, I should be able to do that. And I have a right to do that as a homeowner with one vote in the association. And anything that curtails my ability to voice my opinion to me, that's worse than someone going out and getting 50 proxies from 50 homeowners. I applaud the person who can go out to 50 homeowners and say, hey, I'm running for board of directors. I'd really appreciate if you give me my proxy. Here's how I, think I'm going to serve the association. That's fine with me. And we're talking about due process, and a homeowner has that one vote on who their board of directors is going to be, and they have a right to exercise that. However, within the parameters of the governing documents. And I don't think it should be the law that my proxy doesn't count for the board of directors election, but it counts if you want to raise the assessments on the swimming pool.
All right, Richard and then Joyce.
I'm just looking for a clarification. What happens if I give a proxy to, say, the secretary of the board? And that doesn't mean that I can't go to the annual meeting, but I've already cast a vote. So unless I revoke that proxy, I couldn't vote based on the nominations that have been made for the board vacancies. So then the question becomes, what happens if there's a nomination from the floor? What does that do for the status of proxies? So I think we're kind of wandering into a thicket here that we need to unravel some of these entanglements, because I don't think the parameters are quite as clean as we might think that they are up front.
Thank you, Richard. Joyce?
I think one of the issues is, like, in regards to your free will, is also there are people who are intimidating and bullying in regards to collecting basically proxies from individuals. And so someone may feel like, they have to maintain good relations with their neighbor, they have to agree or go along. So I think there are also those issues as well.
Thank you, ma'am. Connie?
I can speak to Dick's issue about if you have turned in a proxy and then you show up at the meeting. When you show up, you can revoke your proxy right then and there. And Lawless can probably answer whether you walking in the door automatically revokes it or not. But I know once you're there, it can be revoked.
It does. So that's the point, is the proxy says, if you decide to show up, the proxy is no longer valid, and you can vote. It's not like you're going to sit there and let your proxy vote for you when you can do it yourself. A proxy is in absentia being at the meeting.
Thank you.
And very important.
Thank you. Anyone else? All right, Connie, what is next?
Expand HOA Information and Resource Center registration. So 38, 33, 3, 401, registration, annual fees. Registration is required annually to register, and associations will be fined for non-registration up to $1,000 for failure to register. One way or another, our Dora HOA office is good, and I believe one way or another it's going to expand. And any legislation that requires a meaningful expansion of that is going to have a price tag added to it. And a price tag will curtail the best chances of that happening. So one way to help alleviate that would be just require all the HOAs to actually register and fine them if they don't.
Comments? Lawless?
And so how do you know the association hasn't registered if they haven't registered?
David's got a.
What I'm saying is right now, I think the HOA information office has about, I mean, you all would know better than me, but my understanding is that you have about 9,900 or 10,000 registered associations, and there's in fact 10,500 or so associations in the state. So how do you go about sending a letter to the associations that have not registered? You know who they are? I mean, that's what I'm asking, I guess.
I know Nick or Marcia or David can answer that question. They know exactly how many they used to have, how many aren't registered, and they have a number for how many have registered. And Lawless, I need to clarify, I
Sure.
have the number 10,000. I know that there are more than 10,000, so it's 10,000 and some change.
Yeah, 10,515. That's the national, that's from CAI.
Marcia, can you speak to that? How many registered and how many not?
The foundation, CAI. Anyway.
So I'm looking up the stats as of last month as far as how many we have registered. So just give me a minute on that one.
I guess my question, my question is, you do know who isn't registered, and you have a way of tracking that, right? Because I'm thinking if they're not registering, you don't know they exist. That's what I'm thinking.
Well, so we have 8,140 that are active, 3,159 that are expired. So we would know from the expired ones who hasn't, but I don't think from the dawn of time when we've had the HOA program that we know of all of the HOAs in the state, because I think there is still a group that has never registered with us.
Right, that's what I'm thinking. So how exactly would that work? But anyway, the point here is you're making a recommendation that all the associations have to register, which I thought they already knew they had to register. And those that don't get a fine. And then those who expire get a fine. I think 1,000 is excessive, but you know, that's supposed to be a deterrent.
Peter?
Yeah, I think both Connie and Lawless, your points are really valid. But I think that the point of making sure everybody registered is key. And there's some things that you can't manage 100% except for that deterrent. And some of it is on your honor. And if people are trying to hide that they're in an association, okay, you know what? At some point they're going to get tripped up and get caught, and then they're going to have to pay those fines. But I think that the benefit outweighs the negative for, again, a few of those bad actors that are trying to hide it.
Thank you. All right, Connie, what is next, please?
This is under 3833.3303. So what I would add to enhance that is that for any association over 20 years in existence, eliminate at the discretion of and vote by the executive board any maximum assessment amount that may be outlined in the declaration, bylaws, or other association governing documents or good governance policies. So what that means, Mickey, is that there are some declarations that say this HOA forever into eternity will never raise their dues above 5% per year, let's say, okay? So 20 years ago to the declarant, that might have been a really good idea. But 20 years later, it isn't always practical. And this subject came up when public testimony happened last time around. And I remember there was conversation about, well, be glad that you can raise your dues because there are associations that can't. So it happens to be my master association of 6,030 units. There is a 5% cap, and the developers hung on to the association for 20 years. It's only been the last 3 years that it finally got turned over to the homeowners. And this feature is a problem. So I think it's really a lot to put on a declarant to try and predict that out into the future. And I don't know what the number is of numbers who have and who haven't done that, but I know we have an association of over 6,000 homeowners where the increase can't exceed 5% a year, and it's a problem.
Thanks, Connie. Lawless?
I would agree with that. I think that caps on the increases should be prohibited, but the increases should not exceed a certain amount. Well, you're absolutely right, Connie, with regard to it was decided 20 years ago that 5% was all we needed to increase assessments for the next, 40, 50 years. And that's just not realistic. I've had associations where they cannot, it's very difficult to meet the operational costs of the association when the assessments don't rise at the same level. So 5% is pretty low. But say 20%, right? What I'm getting at is, if there's going to be a potential cap, it should not be so low that the operations of the association are hindered from doing what they need to do, or the only mechanism by which they can do what they need to do is special assessment. That's the problem. And then, but I also don't think that assessments should be allowed to increase 50%, for example. Although that's the problem that we're having right now because of insurance, outside factors from the association that they have no control over. But we need to come up with something that doesn't, for example, if you are in an association where you have a 5% cap, regardless of insurance, you have a 5% cap, but you have to pay this insurance bill, which from there requires a special assessment on all the homeowners, and please drop $5,000 in the mail. And so something needs to be done. I do think that caps should not be so low, I guess is what I'm getting at.
Thank you. Joyce?
Yes, I do. I see I see both sides of this, because I see, the need to for the need not to have a cap predicted like 20 years ago in regards to what a cap is supposed to be by a certain percentage. But at the same time, I also understand homeowners' complaints of going into an HOA with a certain predictability regarding how much they're going to be paying, and then all of a sudden being hit with like huge amounts that they suddenly can't afford, which again puts their housing in jeopardy. And so I see both sides of it. I don't know whether just I don't know about just a complete ban. I think the issue needs to be studied further in regards to what the appropriate solution is to manage the homeowners' needs, as well as the needs to make sure that property and the money is there to do what is required.
Thank you. Peter?
Yeah, in one of the HOAs that I work with, their insurance rates this year, and they're trying to deal with it, have gone from $18,000 a year to $120,000 a year. It is, I mean, we all just shake our heads at that, right? So how do they deal with that? So, the cap thing is problematic. Do you take it out of reserves, which is absolutely the wrong thing to be spending for reserves, right? Reserves are really typically what's supposed to be used for capital improvements, roofs and so forth. So yeah, this is a real problem we're having now. And I get it. I mean, as I said, you can see all sides of this coin, and it's probably about a 5-sided coin. But it's very difficult and something that's real, that's reality right at this moment.
Thank you. Lawless?
I keep thinking my hand is going to turn a color when I hit it. But anyway, it's a huge problem because insurance is something that's required and it's out of the control of the association. And it's a problem nationwide. So for those associations that have a 5% cap, yeah, you're capping that, but the alternative is the special assessment. And then in some instances, you have to get the homeowner's approval to do a special assessment, which is another issue or something that I think in some ways should be prohibited, because a special assessment generally only comes along when there is an unexpected expense, like a hailstorm or something of that nature, where you have to come up with a deductible because you haven't been funding the reserves properly, et cetera, et cetera, et cetera. But it is an issue, and 5% just isn't realistic any longer. And then the other problem is, if the association has had this cap for 5 years and on top of that has not adequately funded its reserves, then it's in even more peril because it doesn't have the money to do what it's supposed to be doing, meaning having insurance and things of that nature for the association. So it's a real quandary, but I do think the caps need to go away.
Okay. And again, I'm going to reiterate, it sounds like we have maybe not, we're not unanimous on these issues, but that we definitely had consensus for the sake of the report. Connie, I'm just curious, how many more suggestions do you have? Because I want to make sure we get to item D on the agenda, finding authority and practices, and I expect that conversation to be on the spirited side.
I have a couple more, but I also have one where I literally have said I reserve the right to bring additional Kiowa recommendations. So I would be very comfortable to hold on these because the bill 1105 has 3 sections of what we're supposed to work on. And one of the whole sections is on Kiowa. So I would hope that there would be another agenda before we're done meeting where we could bring additional items, and I would be happy to bring those additional items there so that we can move on with the agenda today.
That would be awesome. Thank you. Does that work for everybody? Peter raised his hand.
Yeah, sorry, just quickly. Yeah, and there was 3 more items that I wanted to bring up as well, that everybody had acknowledged, and I'll wait on those as well. So just as long as we can continue this discussion on the next agenda, that would be great.
Thank you, sir. I think that's great. And Marcia does the agenda, so I'm sure that will appear on the agenda next meeting. All right, item D, finding authority and practices. In that we only have a half hour left or so, I wanted to suggest something because we tend to go back and forth. The 2 topics are what is working well and what could be improved. And I would like to suggest to the group, of course, you're welcome to do whatever you'd like, that first you discuss under finding authority and practices, what is working well. Once that's done, we'll move into what could be improved. So under finding authority and practices, what is working well? What do you see out there that's working well? Any conversation, any comments? Lawless.
Well, I would say that what's working well is the fact that there is finding authority. What's not I mean, I can go into.
We're gonna do that. I just wanted to do the positive and then we'll get into
Okay.
what's not working well. Thank you, ma'am.
Because fines are meant to be a deterrent, not
Right.
revenue. They are a deterrent. And as a deterrent, they work well.
Right. Thank you. Connie?
What's working well, right?
Yes, ma'am.
Okay, HOA, and I'll send this to Marcia too, so she doesn't have to write it down. HOA foreclosures have been reduced as a result of 1137 protections. Jesse Loper has informed us that 1137 noticing requirements are aligned with other foreclosure practices. DOLA's emergency mortgage assistance program that Jose presented to us dovetailed with 1137 so that homeowners at risk of foreclosure had the documentation in hand, the data that enabled them to apply for emergency assistance, saving another 158 homeowners from foreclosure. Some associations have figured out how to incorporate courtesy notices into the front end of any delinquent assessments, saving postage and administrative costs. And it was clear from the testimony last time that some associations haven't figured out how to do that. These aren't numbered 1 through, they're by letter. So E, diversity of language has been incorporated into the statute and recognizes homeowners may speak a variety of languages, and the Klingon translation requests have not materialized. F, daily fines have been eliminated. G, interest rates on unpaid assessments, fines, or fees have been capped at 8%. H, cure timeframes have been established. No fining after a violation is cured, for example. I, cure definition tells the homeowner what must be done to cure a violation. J, a written payment plan offer must be offered to the homeowner in advance of any foreclosure procedures. K, boards are required to vote on legal actions taken against a homeowner, so they can't claim ignorance that, well, gee, the management company acted on their behalf. L, related recoverable attorney fees must now be considered reasonable and are determined by the court, not the attorney. M, if the association has violated any foreclosure laws against a homeowner, the homeowner within 5 years may file civil suit action against the association, pardon me, and seek damages up to $25,000 plus costs and attorney's fees. N, most associations have created the 3 required policies, so collection of unpaid assessments, procedures for covenant and rule enforcement, conduct of meetings. O, a structured payment plan has benefited some homeowners. P, multiple communication avenues, including email and text, have been incorporated into the process. Peter, that gets to your green and efficient, I think. Q, small claims court jurisdiction has been expanded. R, the Metro District Task Force has discussed evaluating Kiowa's consumer protection structure for applicability to Metro District practices. S, CAI's summer edition of the magazine Common Interest in an article co-written by me and David Graff, who's the highly respected Colorado legal counsel and National CAI president, College of Community Association lawyers, included the following affirmations. Posting on the door has been effective in getting the attention of powers of owners to pay their assessments. Non-urgent foreclosures being prohibited is a good thing. Much of the hysteria around adoption of 1137 has not come to pass so far. The designated contact for communication has been a positive development, noting new conversations about how to address community issues amicably and inexpensively have taken place. A shared goal was articulated, finding a balance where people can come back into compliance while the needs of the neighbors are honored for the most part for most of the time. 1137's collection practices eliminated predatory industry insider purchases of HOA foreclosures, and associations may no longer foreclose based on fines and fees alone. And when we get to what could be improved, I also have the downsides, including the ones that David mentioned in that article that we co-wrote.
Thank you, Connie. Does anyone else have any examples of what is working well? All right, then, moving on to what could be improved on. Connie, you were on such a roll. Do you want to go ahead? Oh, Peter's got his hand up, and then Connie.
Okay.
Yeah, as Lala said, a lot of the fines that HOAs use to help manage the HOA and to keep peace within the HOA is deterrent, is really deterrent structure. And 1137 took some of that away, some of that ability. And there's some times when, you know what, it's not really that big of a deal. And there's other times when it's a big deal. So we can get into specifics, but without getting into specifics, I think it's really important to take a look at groups of items that together kind of make up, a section, and then how do you deal with that? And I had mentioned this before, but as an example, there's a group of items that really infringe on the peaceful enjoyment of others in a single building with shared hallways and so forth, and one entity is doing a remodel and throwing drywall out and blocking and blocking emergency access. So the way it's structured now, there's a maximum fine, it's $300, right? And you have 30 days to cure. Well, you know what? You're not going to leave that material out there for 30 days. So, and the contractor says, I don't care. It's only $300. So that deterrent has been taken away from the board to say, you know what, you need to act appropriately. Another one that I have to deal with, and there's actually two of them within the same category, is people breaking covenant to make profit. And one is there are deed restricted units in buildings that are meant for full-time employees.
IKEA since November.
I'm sorry.
Sorry, you guys.
And so long-term. So these people by deed should be renting their units long-term, and that's for employees. People can't afford to pay market rents, and instead, because of short-term rentals, now they're short-term renting their place, and they're short-term renting their place at $500 a night. Well, if your deterrent is now wiped out, you pay your deterrent with one night's lodging, and you can keep renting, and there's really nothing that we can do. That deterrent is gone. What do we do? Same thing that I know that there are HOAs that say you can't short-term rent at all. So those are some of those deterrents that have been taken away. And there's other deterrents that may not reoccur, that may happen once or twice within a 30-day period. So you give people 30 days to cure. And you know what? It's really cured because it's a dog barking, or it's people yelling, or it's a fight that occurs, or something like that within a unit, and there's nothing that can be done. And 30 days later or the next month, it may happen again. These are could be repeat offenses, but they can get cured within that 30-day period, right? Somebody's just letting their dog poop anywhere. You talk to them and it's cured within 30 days. And then after 30 days later, it happens again. So this is a group of items that the fining system no longer acts appropriately as a deterrent. And there's some that are more severe than others. You know, when people, as I mentioned, all of a sudden really don't have to follow the deed restriction and can take a long property that was supposed to be for long-term rental and short-term it because they make a profit. That's just not right. So I love a discussion further and get ideas of, okay, what do we do? Right? This not an easy one. Thank you.
Thank you, Peter. Connie?
What could be improved? A, payment plans should be restricted to regular assessments only, not special assessments. B, statute language clarification is needed that payments in payment plans must be equal but not less than $25. C, statute language clarification is needed on health and safety issues. D, statute language clarification is needed for future payment plans, reducing the payment plan window from 18 to 12 months. E, if and when DOLA's emergency mortgage assistance program ends, we may well see a spike in homeowners at risk of foreclosure, meaning we need to continuously reassess to ensure protections for homeowners who never asked for HOAs and who in large part really don't understand how they work. F, full disclosure. So I told you about the article that David Graff and I co-wrote and the positives that he included. And here were the negatives. So it's only fair to you and certainly fair to him for me to include those as well. So 1, the posting of delinquency notices on doors caused a lot of stress to boards and management teams, noting safety and even a negative homeowner experience. 2, some boards were afraid to foreclose on an owner and cited citations where owner payments had not been made in several years by owners who seemed intent on never paying. 3, the prohibition of foreclosing based on fines alone created a conundrum for associations where owners refused to maintain their homes for years and the potential impact of nearby homeowners' home sale pricing being adversely affected. 4, concern about the maximum fine of $500, particularly for health and I cannot talk today, health and safety issues. And 5, concern about the financial strain on the association in view of the 18-month payment plan, describing, for example, this was a beautiful example, hailstorms and funding necessary repairs involving payment of insurance deductibles and special assessments.
Okay, thank you, Connie. Anyone else have suggestions of where we could see some improvement? Some improvements could be made. Oh, hi, Lee. Lawless. And then Joyce.
Oh, if Lee wants to speak, go for it.
I'm okay right now.
Oh, okay. She said Lee, so I would say the cap of $500 is unreasonable. $500 is a good deterrent for the trash can, but it's not a good deterrent for the RV or the boat or the commercial vehicle or the short-term rental or I could go on. So the cap in my mind is not working in the interest of the association. Now it's working in the interest of the homeowner who would prefer to pay, $500 to have their RV at the house for a year rather than the $250, $300 it costs per month. For sure, it's working for them. And the commercial vehicle and everything that I've said, and any property damages, for example, building a shed that's twice the size of allowed requirements, $500 is nothing. And happy to pay it. Or painting your house in a color that is not consistent with the architectural guidelines of the community, $500, no problem. Here you go. So that's not working. The caps are not working. To me, that's the biggest thing that needs to be resolved is the fines are truly a deterrent that keep people out of foreclosure. Honestly, they don't want as that bill goes up, they yeah, let me get this solved. And daily fines, I'm fine with them having gone by the wayside because I don't feel like most, well, other than trash can, can be solved in a day. Like that's like unrealistic and not really sure where daily fines came from, but they came from somewhere. But anyway, but the max at $500 is truly attractive to the true bad actors in the communities that we manage. So I'd like to see the cap disappear.
Thank you, Lawless. Joyce?
All right, so my actual one was that the fines are still too high. I think even for a trash can or window screen blown off, $500 is a lot for a lot of people. Not everyone finds that an insignificant amount of money. So I think that the fines are still too high. I think that there still is not a neutral appeals process if you disagree or have an issue with a fine. You're still going back to the party who issued the fine, and they're the ones who get to decide whether or not it's appropriate or not. And so you really still do not have a way of challenging it without incurring this significant expense or incurring some type of expense. They still have fines over petty issues, like fake flowers. You can't have fake flowers, things like that, which don't encourage green living either, and also waste a lot of water. And so those petty issues still exist. It was good that the courts are now the deciders over attorney's fees, which actually they kind of were before, but they never really understood the language and just assumed that it meant that they always had to award attorney's fees. I think that there's still reasonableness. There's still an issue for judges, and what does that mean? What does reasonableness mean? And so oftentimes they just, well, I shouldn't say oftentimes, but I think there's some need for like some type of like clarification there or education there, because I think that judges are still struggling with the issue of the definition of reasonableness when it comes to attorney's fees. Attorney's fees, I think, are still too high. And I think even when we're pushing for the mediation process, I think we need to, it needs to be taken into account the attorney fees that are often accumulated during that process as well.
Thank you. Lee and then Lawless?
Thank you, Mickey. I've talked about this issue a lot throughout this process. The biggest things that I see where we need, other than, and Connie and Lawless both had talked about, and Peter, when I came in, about good options where the payment plan, what we had before was a 12-month payment plan for general assessments, and it didn't cover special assessments. Having to cover special assessments now is a problem the one size fits all approach doesn't work, because when you're talking about fines for maybe lower income communities versus fines for wealthier communities and wealthier individuals, the deterrent approach to it, the punishment approach to it is different. The mental aspect of it is different. And so the one size approach has not worked since 1387 was since the bill was implemented. When we're dealing with attorney's fees, it's not like the judges have just suddenly been told they have to determine reasonableness. This is not the only industry where they have to determine prevailing party and reasonable attorney's fees. It's been going on for years, for hundreds of years. Contracts, statutes, etc., have prevailing party provisions throughout them, and the judges are experienced judges for the most part. Most of them are former attorneys. They've dealt with it for their whole career. Then as judges, they're dealing with it for their career. And to question their ability to do so, we have plenty of appellate case law dealing with how a court is to determine attorney's fees, and trying to change it and trying to mess with it for our industry that's what creates the problems. And instead, judges understand what's going on before them. They're the ones that are seeing the cases, seeing the facts, making those determinations. And so that's something we shouldn't tweak and continue to tweak. As far as having the board make determinations as to what the fine should be for a covenant violation, I mean, we do that with municipalities and with governments. When it comes to speeding, the traffic court looks at those. I mean, this is not something that where you have to say we're going to have 5 independent homeowners look at a fine that the board is considering. The board is elected and the board is hired, or not hired, but they're elected. They're not paid, they're volunteers, just like all the other homeowners in the community for the most part. That's part of why they were elected. And so trying to tweak that also to get to some other better system just doesn't make a lot of sense, and is going to result in more litigation to where things are put in front of judges a lot more. It's going to cost associations much more. It's going to cost the homeowners much more, and it's going to result in more homeowners not being able to pay assessments. Then they're going to go through collection, etc., and it's going to be a full slippery slope that we should try to avoid. You've seen a lot of testimony. You've seen a number of people talk in front of this group about what the impact of adding the notices, adding the posting, adding trying to protect one homeowner, what the impact has on the rest of the homeowners in the community. And that's really where I believe our focus needs to be in tweaking this bill and trying to clean it up. Thank you.
Thankfully, Lawless.
Hi there. Okay. I'm gonna start out with if it's in your covenants, it's not petty. It's a covenant that you agreed to comply with when you moved into the association. So again, I hear us, we're talking about all these deterrents, but there is a responsibility by the homeowners to follow the rules and to pay the assessments and to call the management company and make arrangements if you cannot. The true deterrent should be, I don't want legal fees. So how do I solve this problem? I don't want fines. So how fast can I get this taken care of? How fast can I get this, the screen put back on the window, or the paint, touched up, or whatever's necessary. Again, everyone moves in with the same rules. They apply to everyone. And unfortunately, enforcement only has to happen when someone's not following those rules, or they have a tenant who's not following those rules, etc. And so again, the true deterrent should be, I don't want any legal fees. I don't want a late fee. You know what I mean? Like I don't want a late fee. I really don't. And I don't want legal fees, and I don't want to pay fines. So how can I work with the association? So some have apparently come to the association and have not been able to work it out, or we have a considerable amount of homeowners who don't agree. They say, well, I think that's petty. I don't think that's important, or I'm not going to follow that particular rule. Well, there's another thing that's called selective enforcement. And selective enforcement occurs when all the rules aren't applied to everyone equally. When all the assessments aren't collected from everyone equally. You've got, we don't have, this is a corporation, and it has, in the board members, who are volunteers, have a fiduciary responsibility to carry out the operations of the association in accordance with those governing documents. And so if parking on the street's not a good example, but so if RVs are not allowed, they're not allowed. And it just needs to be removed and put in RV storage. If commercial vehicles aren't allowed, it needs to be removed and parked at the place of business and drive your regular car to work. I'm not hearing any, I think what's happening is I'm not hearing any responsibility whatsoever being put on the homeowner. They do their part and we do our part, and we wouldn't have any of these issues at all. And everyone does have a choice where they live. Everyone has a choice where they live. And associations are not for everyone. But the finding, honestly, we rarely have to fine. But for those bad actors, we have to fine. It takes a $500 fine. It takes a $1,000 fine for them to get the RV out of the community, or the boat out of the backyard, or or to paint the fence, stain the fence. And so I think this whole idea of we don't need fines and whatnot. Well, we don't if you fix the problem. And I don't have a problem with fake flowers. Just put them in the backyard, not the front, right? Because we don't regulate the backyards. We regulate the front. Not even regulate, but we're looking at the front yards. Or don't put flowers. Then you don't have to water them. But put something else. Every association has the ability, has offered, options for xeriscaping, or for, all these different mechanisms that we put in place to try to assist homeowners in living in an HOA. And this is what we do every day. We talk to homeowners every day about how can I comply? How can I, and that's 99% of the homeowners who are calling in that are, hey, how can I comply? Can I build a construct so that my, trash cans are behind the wing fence? Can I, what are my options? You can put them in the garage, all these different things. And so I think I just get to the fine conversation, and I'm like, well, we hope we don't have to, but if we have to, we need to have some teeth to make sure that we're following the rules of the association. And some of that can be, you know, homeowners feeling like, well, some rules matter and some rules don't. And that's not actually the case. That's all.
Thanks, Lois.
Sorry.
Joyce?
Respectfully, there's going to be a difference of opinion because I'm sorry, but some of these are petty. And and there is a balance between people just being able to enjoy their homes, people wanting to be able to, on both sides, people being able to not feeling like they're micromanaged, but also people being able to be respectful of other people in their community. And so that's a hard balance. I do think that there needs to be an awareness in Colorado, but even across the country, but especially in Colorado, there are diminishing properties that are non-HOA. Every single year, it gets less and less the amount of non-HOA properties that are available. So this idea that you can just go in and you don't have a choice. You don't have to live there. Go live someplace else. There are limited properties. I have looked. And you can just look at the statistics. There are limited non-HOA properties. So the idea is that we need to be able to find a balance in regards to this. Lee, in regards to your issue, yes, judges are smart. Reasonableness has always existed. I have heard from this directly from judges who are like, we don't know what to do with this, a reasonableness in regards to attorney's fees. So it's not something I'm just making up. I've heard this from judges in regards to that. And I also want us to stop this idea of just if a homeowner just needs to be responsible and people are just not being responsible. Homeowners are responsible. Even if you incur a fine, you are a responsible homeowner. There is just sometimes there are also some bad HOAs, and some of the fines that people incur are not fair. Some of the behavior that is occurring is not fair. So it's not just the same way not every HOA is bad, the same way not every homeowner is an irresponsible homeowner because they get a covenant violation. Thank you.
Thank you, Joyce. Peter and then Connie.
Hey, yeah, I know we're running out of time. We've got 2 minutes left, but I think this is a really good discussion. And this is getting down to some of the real meat of some of the issues that our HOAs, both homeowners and the boards are working through. And for me, it really boils down to looking at the metric of, for a lot of these, of cure time, and looking at the metric of fining. And is it once per the fine problem, or is it once per occurrence of a repeated fine? So the next time I'd like to continue this, and I'd really like to take up the look at the metric on both of those. Thank you.
Thank you, Peter. Connie.
I had my hand up initially because I wanted to say to Lawless in particular, I haven't heard anyone here, certainly not me, say, oh, we shouldn't have fines. So, so that's, I guess, just for the record, nobody has said that. So it isn't about that. And secondly, Joyce did a really nice job of saying we've got to find the balance. And I agree that that's right. Industry is concerned, or the industry people I talk to is concerned that they look bad right now. I think industry is fine. It is the exceptions that we need to get our arms around. So it's, Joyce, it's exactly like what you've said. There are homeowners, for the most part, want to do the right thing. And there are bad actors maybe on either side. So let's not be trashing industry, and let's not be trashing the homeowners, but finding what is the common ground. And Peter, you talked about this at the very first meeting that you had. I think you said that you divided some collections information into 4 different categories. I would love to hear you do a presentation on that and give more than 5 minutes. You know, let's hear what you have to say, because I think it will be constructive, and I'm guessing it will be not favoring one side or another. It's just a different way of looking at things. So thank you.
Thanks, Connie. I'll do that next time.
All right. Well, again, another good meeting today. And I know that the Kiowa stuff will be moved to the next meeting. And speaking of the next meeting, Marcia, do you want to take it or do you want me to?
So based on the comments from the last meeting, we were going to look at shifting these over to Friday afternoons. But I wanted to check with the group as far as, does that create any concerns for you guys? It would be the Friday afternoons in the same week that the Tuesday meetings were already scheduled as. So it would shift it over to February 2nd for your next meeting. So any concerns, voice them now, please.
Does that
Availability
to
for
join
me.
us? Sorry.
Well, and the whole goal was Representative Ricks had said that it would work for her, and I'm assuming that it would work for Senator Fields as well. Lawless?
Just availability, whether I'm available for the meeting or not.
Does February 2nd work for, does February 2nd not work for anyone? And then in the next week, I had my calendar up. We might as well do it while we've got everybody here.
I have the next meeting on the 16th, or this is the 16th. I have the next meeting on the 30th.
Right.
So
But
I am available for that. I am not available for the 2nd.
yeah, so what Marcia was saying was to
Oh.
allow for the Senator Fields and Representative Ricks taking the meeting in the week it was scheduled. In this case, it was January 30th and moving it to February 2nd that week. So is there anyone that does not, besides Lawless, I just heard you say that, does February 2nd not work for anyone else? Okay, and then the week or the next meeting after that would have been, let me see if I have it right, February 13th, and that would move to February 16th. Does
That's
that work?
actually a conference in Las Vegas that Friday, so.
Well, we can all go to Las Vegas, Solace, that's fine.
Well, no, but I'm just saying, like, the Tuesdays, you sent that out early. I've planned my schedule accordingly. Now you're asking me to replan my schedule or everything.
And I understand that, and it's got some conflicts for me as well. As I said,
Yeah.
we did it to allow for Representative Ricks and Senator Fields to be in attendance.
Yeah, Mickey, I can't make that Friday either for the same reason. It is a law seminar and get a lot of my CLEs through that. So.
Okay, so that doesn't work for you. Marcia, are you tracking this? I see.
Yeah, I'm writing it down.
Thanks.
So maybe we just look at February 2nd for right now, and we'll go.
Okay, we'll just look at February 2nd, and then we'll keep that date, keep the future dates on your calendars, and we'll look at it case by case. Does that work for everyone?
Yeah, thank you.
All right.
So let me get this straight. So the January 30th is moving to February 2nd. So I can take that off my calendar.
That is correct. All right, anything else? If not, we will see you all next month.
Thank you.
Thank you.
Have a good week.
Thanks you all.
Wait, did we figure out our agenda?
What, Connie?
I didn't hear what the agenda was. Sorry if I missed
For
it.
February 2nd?
Yes.
It hasn't come out yet.
Okay. I thought you said at the beginning of the meeting, we'd talk about it at the end of the meeting.
Oh, if you had new item, I apologize. If you had new items for the, I apologize, I didn't bring that up. If you had items for the agenda for next meeting. Did
So
you have something? Marcia's still here, so if you have something, we can
Okay,
get
so
it on that.
we've got the Kiowa carryover,
Right?
and we've got Peter's going to do the presentation, right?
What is
I heard,
you're presenting them?
pardon?
What is Peter presenting on?
I heard you suggest that to him, Connie. I did not remember him accepting it.
I thought he did.
Well, and he's dropped off at this point. So
What he said is, I will do that next time.
Okay, and remind us what the presentation was on?
So what he talked about at the very first meeting, that around collections, he had a plan around dividing it. I think he said 4 different ways. I've just been looking forward to hearing what that was and thinking it might take him more than 5 minutes to do that. So I think
Okay.
that's within our purview.
And Marcia, I will reach out to Peter. You can take that off your plate. I'll reach out to Peter. I know he's traveling home tomorrow, but I'll reach out to him.
So the other thing, because we have to keep this moving as far as addressing what is actually in the statute, foreclosure practices is going to be on the next agenda, and probably communications with HOA homeowners
Right,
regarding processes and rights and responsibilities.
right.
Thank you.
All right, thanks, y'all.
Thank you.
Thank you.
See you
Bye.
next month.
Bye.